Started. Once again, welcome, and thanks for joining today's session. ProbateCash provides inheritance advances, a webinar brought to you by ProbateCash. I'm your host, Molly Driscoll. As a reminder, type your questions in the chat window. The presenters will address questions after the presentation. If your question is case-specific and confidential, please indicate that in the chat, and someone will respond separately after the presentation. Our presenters today are professionals with extensive experience in all aspects of providing cash advances to individuals awaiting inheritance payouts. Mark Harris has been working in the specialty finance industry for 25 years, involved in purchasing over $100 million worth of assets. Most of his purchases, pursuant to various state laws, require court hearings, many of which Mark has either attended or appeared as counsel. As a result, Mark has the advantage of meeting customers, their lawyers, and establishing relationships to find a collaborative solution for customers. Mark has spoken at numerous conferences, including the National Association of the Insurance Commissioners, the National Council of Insurance Legislators, and the Pennsylvania Bar Institute. Born and raised in Tallahassee, Florida, Mark earned his undergraduate degree from Florida State University and law degree from Nova Southeastern University in Fort Lauderdale. Mark is married and has 2 children. His son recently graduated from FSU and now attends NYU Law School, while his daughter currently attends FSU. Today, he's here to speak about the relatively new business of purchasing interest in the actively pending inheritance claims. And hopefully we'll be covering all of your questions, but we'd love to be keeping the conversation going after today's talk. So please don't ever hesitate to reach out to Mark. You can call him at 561-476-0018 or email him at mark, and that's MARC, at probatecash.com. How is this different than a loan?
This is not. So these are not intended to be transactions where we buy out an heir's entire position or interest in the estate, their inheritance. The goal here is to provide the recipient with interim cash sufficient to meet their current needs while still keeping the heir's skin in the game, looking forward to the ultimate wind-up and distribution in the estate. We want the ultimate settlement of the estate and distribution to remain of interest to and a priority for the heirs we fund. And so this isn't a loan. There's no credit search, there's no fixed due date, no interim payments of principal or interest, no stated rate of interest, and no personal liability on the part of the recipient if the estate turns out to be insolvent or if the proceeds distributed to the heir come short of what was originally intended. So the only situation where we're going to have a claim against a recipient is where the estate pays out, the recipient gets a hold of their inheritance and just doesn't pay us. Of course, that's stealing, that's fraud, and we're going to try to get our money back. But if the property sales are disappointing, like the estate home sells for less money, and the amount of outstanding debt eats up the proceeds otherwise due to the beneficiary of the estate, or it all ends up taking just many, many years, longer than we thought, before the assets are distributed, that's our risk.
Do you purchase the entire inheritance?
So at ProbateCash, the general practice is not to purchase the entire inheritance. As I said, we want to ensure that the beneficiary has that skin in the game, has funds coming to them when the estate closes. So we want to ensure that the heir, the beneficiary, has motivation to continue to be cooperative and complete any item necessary to usher the estate towards closing. You know that you are giving correct information to whether it's your client or to one of the beneficiaries who just keeps calling, where's my money, where's my money? You have to know that you're giving out information and referrals that aren't going to adversely affect your client or the other beneficiaries, which we know you don't want.
What happens if ProbateCash overpurchases?
Again, ProbateCash takes the loss if there's a shortfall. The other things you should know is there's no lawsuit against the estate, attorney, or the heir if there's a shortfall. We absorb the entire loss or whatever can't be paid. It's our job to make sure we underwrite our transactions correctly. And since these are purchases, not loans, if we overpurchase, it's non-recourse. So if the estate takes a loss, gets it with a last-minute IRS lien, Medicaid, Medicare, or any way becomes insolvent or unable to pay the entire assignment, that's on us. There's nothing for us to do.
Does everyone have to be on board?
Again, all parties, not all parties, I should say. So the heirs, estate attorneys, and executor need to be on board for somebody to get an advance against their inheritance. It's just a contract between us and the one beneficiary who wants the advance against the inheritance. They don't need approval. We understand that not all beneficiaries communicate well with one another, or it's family, so they probably don't even like each other. So we enter into the contract with just the heir and file an assignment with the probate court. That being said, we strive to receive cooperation from the estate's attorney or the executor. To that end, we do proactively attempt to contact the estate's lawyer and make sure they're aware of the heir's assignment. We don't like surprises, so we find that transparency is always the best practice. Your office isn't going to like surprises either, so we keep everybody involved.
If an heir or a client called you and asked you about getting an advance on their inheritance, what would you say to them?
Since you asked, this is you guys taking phone calls too, and of course I preface this by if you work at a law firm, you want to talk to the attorney, because I wouldn't want this final decisions being made without my knowledge either, of course, but it depends on whether the question came from your client, so in this context, usually the executor, or from an heir who wouldn't be my client, but still kind of a constituent because it has to do with the estate. In either case, I want to make sure that my client or the heirs have the ability to access money as they need it. Now, I'm biased because that's our business, but our business is popular because we provide money to people when nobody else is willing to do so. Who else is going to advance somebody money against their inheritance while the claims period is proceeding, before the claims period begins? So we'll provide that advance money at that point. So I might briefly explain to my client the process. Know that this kind of this kind of advance can come with a cost at the end. It will come with a cost at the end, and ask if they had any other source of cash to meet their immediate need. Now, if the question came from an heir who's not my client, who is anxious to receive a portion of their inheritance now, I tell them I know a company that can provide immediate cash today, but that it's up to the heir as to whether it's something they want or need to do. If they're intent upon proceeding, I probably would remind them I'm not their lawyer, but would cooperate as much as I can under the law. Now, one other call you may receive as paralegals are calls from people who need to open a probate case, but don't have money to pay a retainer or cover the cost. So someone calls in, my family member passed away, I need to open up a probate, and you or your firm says, well, we can do it, but it's a $10,000 retainer, for instance, $5,000, $10,000 plus cost. Maybe your firm doesn't want, or you as a paralegal do not want to wait until the assets are distributed. In that situation, you need to ask and learn, find out whether or not the estate has any assets that are going to be sold. Because if the person doesn't have any cash to pay a retainer agreement, we may be able to help at that point. We can then come in and advance money to the beneficiary, the prospective executor, and say, all right, here's money, authorize us to pay it to the law firm, the attorney for the retainer agreement, and then you can open up the probate. Now, would we do that if there's not a house to be sold or other assets to be sold? No, but oftentimes an estate home is the big asset. The estate doesn't have a lot of liquidity, and that estate home will be sold, and then that's how the beneficiaries will get paid. Or it could be another asset too that's not liquid that needs to be sold. That's where we come in and make advances, really, not just against the inheritance, but also in anticipation of those assets being sold. So basically, the bottom line is you don't necessarily have to turn down a case because the potential new client doesn't have upfront money. That's when you definitely want to give us a call.
Now we have another question that's, what's the common borrow amount?
So that's a good question. So really, it's an advance amount. These aren't characterized as a loan, so there is no borrowing, but we will advance as low as $3,000 we've done, but we'll do as high as up to $500,000. So it depends on the assets in the estate. We do our own underwriting. We try to get back to the beneficiary or to any referral source in as little as 24 hours. And in fact, we've even funded advances within hours of the request.
Oh, wow. Now, I think this is kind of in reference to what you were talking about towards the end, Mark. It says, can you further expand how my firm gets paid if my client doesn't have the money to pay me?
Sure. So if you're taking a call and the person can't or is unwilling to pay, and instead of saying, well, sorry, we can't help you, we like to try to solve some problems. So we'll say, okay, what assets are in the estate or do you anticipate being in the estate? And if mom and dad have to sell the home, the decedents are selling the home, that's the usual asset that's being sold. But it could be a business, it could be pictures, it could be all sorts, it could be even bank accounts, stocks that need to be eventually liquidated. In that situation, we understand that nobody has access to that cash right now. In fact, if they did have access to that cash right now, we wouldn't be in business at any time. But in this situation, even before probate is filed, even before we know whether claims are going to be done, we don't have a clear picture of the inventory. In situations where they need to open up probate and there are assets there, we can advance the beneficiary money. The beneficiary authorizes us to pay that money directly to their lawyer or paralegal, whomever's opening up that estate. And we make that advance pursuant to their instructions, and that goes right into the law firm or paralegal's money for their fee to open up the account. And let's cover the cost as well.
Okay, this question might be kind of in regards to that. It says, so if the personal representative on a probate doesn't have the money to pay it says staff fees. I'm not sure if it means state fees. ProbateCash can help with that.
Yeah, so on again, the answer is probably. We have to look at what the rest of the estate looks like. So if the personal representative doesn't have money, we come in, provided the personal representative also is either a beneficiary of the estate, or if there is a beneficiary of the estate, we can advance to that person. But usually the personal representative is often a beneficiary. We advance money to them, and then we get the estate opened up. So now you have a new client. And what we do with this case and every case, once the probate case is opened up, we actually file with the probate court the assignment of the inheritance. And that way the personal representative will know, and so will the probate court, the judge, that we do have the advance outstanding, and the beneficiary is assigned X dollars of the inheritance. So let's say there's a $20,000 assignment of someone's inheritance. It's filed with the court, and when the estate assets are ready to be distributed, the personal representative knows to pay us the $20,000.
Okay, great. We also have a question. What's the fee schedule that ProbateCash charges for advance? That might be too specific, but maybe some kind of overall.
Yeah, the fees. So that's a very good question. That's what most people want to know, is how much does this advance cost to me, right? So again, it's non-recourse. We don't get to sue the estate or anyone else if there's a shortfall or there's claims that wipe out the estate. But we charge on a fee schedule. So they could be as low as 15%. And up to very high fees, depending upon how long the estate or the advance is open. So the advance can be repaid at any time, even if the beneficiary can repay us from funds that are not associated, for instance, with the estate. They can still repay us. But if the longer it's out, so if the estate is out for a year or more, the fee is going to be considerably higher. Now, likewise, the more cooperation we receive from, for instance, the counsel for the estate, and we have a good picture, we think we're going to be paid back, we can even negotiate those fees. So it really is a case-by-case basis. We do our underwriting. It could be as low as 15%, and it could be significantly higher. Well, there's one other thing I wanted to add, because I don't think we talked about it. We know that everybody's time is valuable, and you're taking these calls. We also will agree to pay referral fees. So if you're getting the calls and or you have other folks who weren't able to join today, or people about us, please send them our way, and we'll pay referral fees for based on the advance amount. We have a large group of lawyers throughout the country and paralegals throughout the country. We work with notaries, we work with realtors, we work with a lot of folks who refer our business, and we're happy to get that business. We're happy to review it, and when it works out, we pay referral fees at the same time that we pay the advance. So even though we may not get paid back for a year, sometimes 2 years, referral fees get paid at the time that we make the advance to the beneficiary. So that means you get paid right away.
Well, I'm sure that's information everyone needs to know. And so if there is any more questions, please don't hesitate to contact Mark directly, or you can call Mark at 561-476-0018. You can email him at Mark, that's MARC, @probatecash.com. And thank you so much for joining us, and talk soon.